May I please your lordships?
Yes.
My lord, the central government issued a notification dated 29/5/2015, and that is a notification which is the result of a long drawn-out process of consultation between the Ministry of Finance, Ministry of MSME, Indian Bankers Association, the MSME Association, and my lord, in a small way, I was also a party to the formulation of this notification, because I also got a number of representation on behalf of the MSMEs. So from 2006, it took 9 years for the notification to become a reality. And this notification was not given effect to by not a single bank or financial institution in this country. And your lordship not feel that I'm not criticizing the court, no, not in that sense. I'm only pointing out agreements. Every petition, one after another, came to be dismissed, saying that either come with unclean hand, this or that. There were so many reasons, and one of the reasons offered was, but there is a provision under section. It is repeated in so many cases. Your lordship would be aware of section 26, 26E, the 26E of the Securitization Act. Securitization Act. So section, may I take your lordship to section 26E? So 26E of the Securitization Act. I have noted it. 26E of the Securitization Act. Yes. It is here. I'm sorry, it's just 26E of the tab. All from the tab. 26E of the Securitization Act says, prior to that, the 26E was introduced in 2016. Prior to that, my lord, the scenario was that between a MSME as a creditor and a financial institution as a creditor, by virtue of Chapter 4 and Section 24, MSME as a creditor has a.
Issues have been dismissed. Pardon
my lord?
Issues already dismissed.
Now the issue, your lordship, even you take your lordship, take your call, your take it. I don't have any role in that. I'm only attempt is to bring the grievance to your lordship's notice. Whatever way your lordship takes, that is not there in your lordship's hands. Now the grievance which I'm pointing out was, when this notification was cited, one of the reasoning, the number of judgments, the relief was being denied, relying on a judgment of the Supreme Court, this court in Kotak Mahindra versus Gunnar Industries. The dispute in that case has nothing to do with a lender and a borrower. It has nothing to do with MSME cases at all. The reason that section, the Gunnar case, the Kotak Mahindra versus Gunnar Industries, the issue was between an MSME as a creditor and there's a bank as a or financial institution as a secure creditor who has a primacy. Prior to the 2016 amendment, the MSME as a creditor has a primacy. This judgment has nothing to do with the cause of the MSMEs. But this judgment has been repeatedly quoted. So much of injustice has been done in the name of precedent. So, my lord, I ordered an article where all law reports the same the judicial system, the justice delivery system. So, precedent, my lord, it has been so much abused. Now, no connection whatsoever. And that was the reason offered for denying benefit under the benefit under the MSME Act. And may I take your lordship to what is the scheme of the Act? The lordship ultimately disagree with me, my lord, but if I am able to persuade your lordship that, my lord, it will save the cause of thousands and thousands of MSMEs. And my case is so simple, undeniable, as clear as daylight. May I take your lordship to page 70? Page 70, my lord, the MSME Act, page 70. Because this issue concerns so many people. You have to discuss one petition, another will come up.
This is a PAA or what it is?
Pardon me, lord?
Is this a PAA?
No. We are all persons agree. My lord, PAA can.
Proceeding because there you can always raise all these issues.
No, my lord, all PAA concept is in ignorance of basic jurisprudence. There can be representative proceedings, or a person aggrieved can come forward. May I take your lordship? So,
The petition.
may I take your lordship to page 70?
Yes.
Page 70. Identification of incipient stress. Before a loan account of a micro, my lord, note it, madam. This is Manmohan, page 70. Before a loan account of a micro, small and medium enterprise turns into a non-performing asset, banks or creditors are required to identify incipient stress in the account by creating three subcategories under the special mention account category as given in the table below. A. SMA 0. Principal or interest payment not overdue for more than 30 days, but the account showing signs of incipient stress. Number one. Second is SMA 1. Principal or interest payment overdue between 31 and 60 days. So under this scheme, the bank has to identify incipient stress. And the RBI's notification says what are the incidents of signs of illustrated signs of incipient stress. A simple example is a dishonor of a check.
You raise all these grounds in the proceedings initiated against you.
Yes, my lord, the problem is
that.
My lord, matters are pending, my lord.
So how can we deal with?
No, my lord, there is no, I'll answer that, my lord. There is no restricted under the first principle.
What are you saying? No restricted.
Restricted, my lord, if I don't.
We can consider some legal issue valid.
No, my lord, no. So for a restricted, I am quoting from civilians. For a restricted, there is another way I have got Latin. There is no substitute than in English than Latin. I am quoting for civilians. That is, my lord, for a restricted to constitute, my lord. Si omnia sutidam, idam corpus, idam quantitas, idam just, idam, idam, I forgot, yeah, idam quantitas, forgot it, yeah. Idam cosa petendi, and idam quantitas personarum. I may have made a mistake. Therefore, now, for a doctrinal restricted to apply, that the cause of action should be the same, the parties should be the same, the cause of action should have been adjudicated on merit, and cause of the doctrinal restricted belongs to the realm of facts. But to put me as a restricted ex albo negrum, ex nihilo album, ex recto verbum, ex capo recte. Judicial decision on facts can make what was white black, what was black white, what was straight crook, what was crook straight.
Issue of voice decided in the pronate matter has been confirmed by Justice Datta in a separate.
No, now,
and your petitions are dismissed at
no, the party
keep on coming back again and
party is partial. Party
373.
What is please some correction. And the Datta statement also
Repeatedly, no.
Now Krishna is also note. With the result, the benefit under the notification is not made available to a single MSME.
There are judges of this court.
If your lordship is this code is wrong, it has to be corrected. No matter on question, these are the estoppel against law. There is no estoppel first principle. There is no estoppel against law, and this court has said in Canada Bank, Justice Nadiman's statement, Mara 34 4. There is no estoppel against law. Estoppel, Dr. Estoppel, Residicata applies only in respect of facts. Residicata pro veritate acquipeter. Judicial semper pro veritate acquipeter. That can happen only in respect of facts. On facts, on law. This court, your lordship is a servant of law. Your lordship duty is to administer justice in accordance with law. And if your lordship decides a wrong contrary to a statute, it is not the statute that will prevail, and not your lordship's judgment. So when there is a conflict between a statute and there is a conflict between a judgment, it is the statute that will prevail. And therefore, where will I do? Can the litigant go and say to end of the street? No, I don't belong to that. I don't support that proposition. All issues has to be resolved in the constitutional means. I believe in Gandhian philosophy. All has to be addressed before the court, before constitutional means. I will never ever support a proposition that if you don't get justice from the court, you have to enter the street. No, never. As a lawyer, I will never do it. Your lordship decided to dismiss it today. There are thousands and thousands of us. They will come tomorrow. thousands of people without a consideration, it cannot be an issue, cannot be a solution at all. Justice Datta's case, that was just like a mob. Yes, Katika judgment. No notice was issued to anybody. Nobody was scared. A judgment was dictated in the open court and pronounced in the open court. Yes, right.
Yeah.
So therefore, nothing was decided. And again, assume that you let us go by Justice Datta's judgment. Then within that parameters, whatever correction be done. Before Justice Datta's judgment and even after Justice Datta's judgment, relief is denied. I have produced it. One example, my lord, I take your lordship to one of the cases, that is Esteban. My lord, I took up this issue even after Justice Datta's judgment. My petition was dismissed. I then filed an SLP here. SLP, your lordship was pleased to dismiss it 1 minute. I was not even here for 1
We are
second.
not dismissing in 1 minute, 15 minutes.
No. I'm taking your lordship to page 449. Page 449.
Yes.
Page 449. Justice this is the page 449. Yes.
Today all your cases will be
No,
will be ending up 1 hour.
yes, my lord, page 49, my lord, because now, my lord, if your case is properly decided, it will save a lot of time. This lady came, filed 57 petitions. What for that? A notification which a child can understand, a matriculate can understand, which only says, banks are under a duty to constitute a committee, make a effort for resolution of stress, and if it is possible, go and recover. And the notification also says MSME, if able to identify incipient stress itself, we can make an application. It's simple. It offers no difficulty. The Bombay High Court dismiss it, Madras High Court dismiss it, Kannada High Court dismiss it, Gujarat High Court dismiss it, and then we came before this court. First instance, dismissing an SLP without a due thought is a big problem. The Bombay High Court rendered a judgment in a matter 18 matters, and by judgment dated 11/1/2024, the SLP was filed. She filed the first SLP. She is the president of the MSME Association, and the bench of justice cannot dismiss in 1 minute. And thereafter, my lord, she filed a review petition that was dismissed. In the meanwhile, other co-petitioners filed SLP, and that was admitted by the Justice Bella Trivedi's bench. And Justice Bella Trivedi's bench also dismissed it after many matters were dismissed. So we persisted, and therefore it was going to be admitted, and it was allowed.
She has passed the speaking judge.
No, there's a
speaking judge.
Against the one judgment of the Bombay High Court, different SLPs were filed. Many SLPs were dismissed.
That's
let me take this.
That's our
449.
Thank you.
Let me take it to 449.
No,
We have seen.
No.
We have seen.
No, your lordship has not seen it.
It's covered. It's covered.
1 minute, my lord.
We hear and all these
No,
things.
I am not, your lordship may not agree with me, but just hear me.
That's all right. We have
Yeah.
3 minutes we are hearing.
No, your lordship may hear me so that your
We have
lordship.
already heard you.
No, my lord, let me take this page for 49, 1 minute.
We are not to hear everything. We have
No,
heard you.
my lord,
We have seen.
my lord, my lord,
seen the earlier orders.
No, my lord. See, my lord, I don't want to blame the courts. Never. I never wanted to do it. If it was possible, I wanted to praise the court judges only. Never. I wanted to follow Pandilian principle. Praise the judge. I always want to do that. But sometimes I have to point out the deficiencies. And may I take your lordship to page 449. 1 minute, my lord. 1 minute. 1 minute, page 449. Justice Datta's judgment says, if I reply to a 13-2 notice, if I have pointed out that an MSME, then the benefit has to be extended, right? That is Justice Datta's judgment. I page 338. I read 338, my lord. Half a sentence I am reading. 338 from here, page 338. However, upon receipt of the demand notice, if such a borrower in his response to under section 13(3)(a) of the Surface Act assert that if an MSME claims the benefit of the framework, citing reasons supported by an affidavit, the lending bank or security creditor would then be mandatorily bound to look into such claim, keeping further action under Surface Act in abeyance, and should the claim be found to be worthy of acceptance within the framework, to act in terms thereof, securing revival and rehabilitation of the family.
And the last paragraph at para 10, that you will raise your remedy under section 70.
No, this is a different. No, this is a different party. No, your lordship has No, your lordship has completely misunderstood.
370, 380.
No,
your restrictions are displaced.
No, your lordship has.
No, 317, 318 is your interpretation.
Your lordship has completely misunderstood.
No, please see. 317, 318.
No, my lord,
Please find those petitions.
I'm on that.
317, 318 is your petition which has been dismissed.
No.
You are coming back again and again.
No, my lord, that is the different. My lord, your lordship has completely misunderstood.
No.
Let me explain.
That's all.
No, your lordship.
Thank you.
The point I wanted. The point I wanted is different.
Thank you.
The point, no, just your lordship understand what I want.
You
to discuss it.
Yes.
No, 1 second, my lord. If your lordship, I am
You
only
understood.
to say.
317, 318 is your
No, that is not what I am saying. I am saying is something very different.
Yes.
What I am saying is, after Justice Datta's statement, saying that if you are MSME as you have pointed out, let me complete it, my lord. Let me complete it. Yeah, Justice Datta's statement says, if a MSME points out that after 13 due notice is issued, the reply gives the reply saying that I am an MSME, then the benefit should be extended. Then, in the case at page 450, I replied. This batch petition, I
What
replied.
is issued in those proceedings only, no
No,
indication.
my lord, I came before this court. After that, no, my lord, after Datta's judgment, I came before this court. And my lord, my case was dismissed without hearing me even for 30 seconds.
Well,
I
let's
only
we have heard you for 20 minutes.
No, therefore, my
For
lord,
1 minute you said we have heard you.
no,
That's enough.
my lord, what this man will do? My lord, what this
Next
man
case,
will,
please, sorry.
my lord, what this man will do, my lord?
What?
Your lordship,
We have to deal with cases only,
No, no.
not answer your question.
No, my lord,
Right?
no, my
That
lord.
we have heard you.
No, my lord, in the constitutional democracy, lawyers have freedom to ask also. That my lord,
Fine, we are not answering.
that is, my lord, we have to accept, my lord.
Create, who is there? Yes.
My lord, no, 1 second, madam. Then what will I do? Your lordship may say something so that I can correct it. This is Manmohan, my lord.
We have said so. Please
You know, your lordship may say something should not house. My lord, our grievance is that my lord, justice should not be denied.
Thank you.
No, my lord, your lordship, my lord,
You heard you.
whether it's one thing, whether it's principle.
Unlitigating. Abuse of mercy of God.
Hurry of justice.
If you want to
is
hear yourself, you can be our guest.
No,
We are willing to sit till 4 o'clock. That's not a problem.
Then allow me to say this one sentence. Once this matter, what I was saying,
18, your expedition is dismissed.
peacefully, my
You are
lord.
coming back again and again.
No, my
You
lord,
come back again and again.
no, my lord, now.
Only a bad penny comes back again and again.
No, my lord, now, but my lord, I am asking
you,
for,
yes.
one second. What I am asking for is what is done in Andule's case. Andule's case, Supreme Court has said if an injustice has been done, if it is within the means of human, within human machinery, if it is possible, it should be corrected. Can this speak only with Andule? And not all ordinary litigants? Andule was the chief minister. These are hundreds of thousands of
All right.
Therefore, my lord, I rely on Andule. Give me, extend me ex debito justitia. That is what Andule said. It is Latin, not me. Andule said ex debito justitia. Second, in Andule it is actus curiae nominum probabit. Actus curiae nominum probabit. For a mistake of a court, nobody should suffer. But not I suffer because your lordship has dismissed the SLT without hearing me 1 minute. I was in Cochin, I said, my lord, I come physically. Then your lordship said, no, you have to say that at the beginning. Now that opportunity is lost. Therefore, that is harsh. That is harsh, my lord. That has to be corrected.
Yes.
Well, first and foremost, if I may just indicate to your lordships that we had filed an application under